Hello, my name is Dave Zapponi, and I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in today's Ask the Attorney event. Today, we will focus on case law and how it affects the HOA legal landscape. We would like to ask all our non-speaking participants to mute their mics and to turn off their cameras. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on the screen. In addition, slides were sent to each registered attendee beforehand. Please take a moment to review our housekeeping items. We have many HOA board members present today, which usually means we'll have a lot of questions. You will have a chance to ask your questions of the attorneys directly during our 2 20-minute breakout sessions. Please use the chat icon to report technical issues and to communicate directly with other participants in the webinar. You will find the chat icon by hovering over the bar at the bottom of the page. I will respond in writing to some of the more common questions, easy questions, and statements in the chat during the presentation. Please keep your questions general in nature. Questions about specific situations are better asked one-on-one with your professional counsel. And now for our disclaimer, which you'll see on your screen. None of what is said during this seminar shall be construed as specific legal advice or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. Thank you. Today, we have several sponsors. Please join me in thanking our premier sponsors, the Kevin Boland Insurance Agency and CID Consortium, LLC. Our program sponsors are the Camera Management, Inc. and Tinley Law Group. Our registration sponsor is Silver Creek Association Management. Now, we will have a few words from our premier sponsors, CID Consortium, LLC.
HOA board members are volunteers from a variety of backgrounds who face complex legal, financial, social, and maintenance challenges. CID Consortium, LLC is proud to support educational opportunities for volunteer board members and HOA members. At CID Consortium, our purpose is to enhance your community living experience.
And now we'll hear from the Kevin Boland Insurance Agency. Connor, do we have a video for Kevin?
No, he was unable to make it this morning.
Okay, well, Kevin is a longtime supporter of our programs, and so we thank him for all of his work. I had an opportunity of visiting with him recently. He'll also be speaking in an upcoming Ask the Expert insurance program. So thank you to Kevin. He's always been a strong supporter of ECHO. We also will be giving away 3 $50 gift cards courtesy of our gift card sponsors, Divergent Consulting, George Peterson Insurance Agency, and Silver Creek Association Management. Please stay until the end of the webinar for a chance to win. Thank you to all of our sponsors. They make this event affordable to anyone. We are excited to bring, we are excited to bring attorneys from 3 law practices today: Angus and Terry LLP, Community Legal Advisors, and Pratt and Associates APC. Here is a little bit about each presenting attorney. Mark Gutthews, Esquire, is the founder of Community Legal Advisors, Inc., which represents more than 500 HOA communities. For more than 20 years, his firm has provided general counsel, legal advice, and assessment collection services. Mark also serves on the ECHO Board of Directors. Lori Masoto, Esquire, is also with Community Legal Advisors and has been a practicing attorney representing homeowner associations in Southern California for more than 27 years. She is honored to be involved in educating directors, managers, and industry partners about the laws involving common interest developments and has built many long-lasting relationships in the industry. Anna Cunha, Esquire, is a partner with Angus & Terry LLP with extensive experience representing common interest developments of all types and sizes, and is general counsel to many homeowner associations throughout California, advising boards on many aspects of HOA law. And our final speaker of the day is Sharon Pratt, Esquire, founder of Pratt & Associates, APC. Ms. Pratt has over 30 years of experience specializing in common interest development law. Sharon is also an educator that has provided regular trainings to HOA boards on a variety of topics, including corporate governance, elections, and fiduciary duties. We will now move into our first planned presentation for the day, presented by Mark and Lori of Community Legal Advisors. Mark, please take it away.
Well, good morning, David, and it's a pleasure to be here. What we're going to talk about, Lori and I, we've kind of divided the presentation into two parts. And the first part is really just understanding sort of the conflicts of law, the statutes, how the statute and the case law work together to provide associations directions on how to implement the law for community associations. So my part of the presentation is really just looking at how does law and statute and case law work together. Then Lori's going to drop in and talk about maintenance responsibilities for the community and what the court's expectation is going to be of your community association should you end up in court. And that's, of course, how all of us attorneys advise our associations. So let's go to the next slide, Connor. Okay, so I'm going to give you sort of a loop. So the first step is the legislature. You know, people will say, you'll hear from time to time, you know, there ought to be a law about that. That should be illegal. We should, you know, the state should require this. Okay. Sometimes with little more clarity or direction than that, we get a law. Legislature drafts this idea or concept into a statute, which is passed around between, yes, it is California law, which gets passed around. But this principle or these principles is how it works everywhere, California, state, federal. Okay, so this idea gets written down, and that is a statute. That is a proposed statute, and it gets passed between the two houses. And if it passes each of the house, the governor has the right to block it, but generally the governor will sign it and it'll get passed in law. And then people like Sharon and Lori and I sit around and we say, okay, I think what they're trying to accomplish when they wrote this law is this. You know, I think when they wrote the Open Meeting Act, what they're trying to say is all of the conversation that takes place at the association at the board of directors level should be in an open meeting. I think that's what they mean by that. And yet they wrote in these exceptions that allow for negotiation of contracts. Does that mean that it's just the negotiation of contract that goes into executive session? Or does that mean that all of the signing of the contract, maybe the signing of the contract should be done in an open meeting? At what point does this divide? And the answer is there's no language, there's no direction in the statute. It's really what the courts call a plain reading of the statute. And that's what we all do as practitioners, and we try to implement that. And then we talk to you and we say, hey, here's what you need to do. You need to give 4 days notice before you go into a meeting. And if the things you're talking about aren't on the agenda, you shouldn't talk about it at the meeting. That's an operable protocol. That is based on what the statute says. We think this is the law. It turns out that attorneys disagree. You know the old joke, if you get 3 attorneys in a room, you get 3 different legal opinions. Well, we read the law differently, and we're all egotistical. We are all convinced that we are correct, all right? And so what happens? Well, one attorney directs their client one way, another attorney directs their client another way. And then ultimately, associations get tired of us attorneys, and they hire one and they fire the other, and they look back and they say, well, wait a minute, you weren't advised correctly. This isn't right. Or an owner will say, you know, they'll hire an attorney from outside the industry that will have a different point of view on what that law really says, and they'll challenge our protocol. They'll say, hey, you can talk during meetings about things that aren't on the agenda, and here's why. And then we go to court, right? So either we settle or we go to court. So what happens is the court looks at our 2 different arguments. They hear both of our arguments, and then they record. They say, okay, well, we're going to make a decision in this situation. And I'm often tell clients, courts don't give you justice. They give you a decision. They record the reasons for their interpretation, and they write it down, and they call that case law. So what is the case law doing? It's interpreting, it's the court's interpretation. So before you had attorneys making interpretation, now you got the court making interpretation. Then all of us read the case law and say, aha, based on what the court said and what the law is, this is the new protocol. So it's kind of a loop which occurs, okay? And that is how statutes and case law work together to give us directions. At the start of the class, I said that I'm going to give you some direction on conflicts of law and primacy of law. Very quickly, if there is a conflict in law, if 2 statutes say completely opposite things, then we're going to look at what is the origin of that statute. So if the statute says, if the statute comes from the federal government, that statute is we're going to follow that instead of California law. So for example, California law says that the association has authority to govern flags and can limit flags, okay? Federal law says they can't. California law says that the association can keep satellite dishes from being installed on the exclusive use common areas or within the unit. California law says that the association can limit that. Federal law, the OTAR rule, says you cannot. So we follow the 800-pound elephant. If the bigger entity, if the federal government says this is the law, we follow that. If the state government says this is the law, we follow that. Generally, most of our laws are contained within the Davis-Sterling Act, okay? And that's fine, but that also gets confusing for people, and I'm going to explain why. What people say is, well, do we follow the Davis-Sterling Act or do we follow our CC&Rs? And the answer is both. The Davis-Sterling Act was written after 80% of the CC&Rs in California were written. The Davis-Sterling Act understands that existing CC&Rs continue to exist and says, what can we do to work within this pool or pond of existing restrictions? So this Davis-Sterling Act has kind of 2 approaches to doing that. One is called notwithstanding, and one is called unless otherwise stated. I'll give you examples of each. One part of the law says, notwithstanding, no matter what the CC&R say, anybody's CC&Rs, you can only raise assessments 20% without getting membership approval. You can only special assess owners 5% without getting membership approval. That is a statute at the state level, which says no matter what's in CC&Rs, this is the rule. Another statute, same Davis-Sterling Act, says, unless otherwise stated in the CC&Rs, The association maintains the common areas and the owners maintain their separate interest. Classic situation where the same state law is reaching down to the CC&Rs and saying, hey, we're going to follow what you had to say. But if there's nothing stated, this is going to be the law. Okay, so we have statutes, we understand primacy of statutes, and we understand how statutes and case law work together. Let's talk a little bit about why this is so important. Let's go to the next case. Let's go to the next state. Statute says any deed, declaration, any CC&R restriction shall be liberally construed to facilitate the operation of a common interest development. So the point is, we're going to look at the CC&Rs and we're going to try to make them work within the confines of California law. Next slide. The common interest development shall be managed by the association, which shall be incorporated or unincorporated. This is the law that says that the association is managed by, the physical corporate association is managed by a nonprofit mutual benefit corporation. Might be an unincorporated association, but for the most part, it's a nonprofit mutual benefit corporation. What does that mean? Next slide. It means that it is governed by a majority of the board of directors. A majority of the board of directors is a fictional thing. It is 3 out of 5. I'm just looking at the first 5 names on this Zoom call. David, Sharon, Kay, Lori, Carol. That's 5 people. At any given time, David, Sharon, and Kay might feel one way and Lori and Carol might feel another. The decision of the corporation is the decision of the 3 of them. The next time, it might be Carol, Lori, and David that agree on something, and Sharon and Kay both know in the core of their being that this is a terrible decision and vote against it. The decision of the corporation is the decision of a majority of the board, even though that majority changes. Okay, so get to your question in a second. So what does that mean? If we know that the corporation, the association, is governed by this board of directors, what are the directors' duties and how do they keep from being sued for doing their job? They are elected to do this job. What are their duties? This is called the business judgment rule. The director is called to perform the duties of a director, including, let's say, in a manner such director believes in the best interest of the what? In the best interest of the 5 people who voted for them? In the best interest of their best friend Joni? In the best interest of the corporation. Their job is to make sure that the decisions are made soundly and the corporation doesn't get sued. How are they supposed to think about doing that duty? Well, they need to do reasonable inquiry. They need to ask questions. They need to not sit quietly and just accept what everybody says. They need to be a prudent person. They need to think about what would an ordinary person, i.e., what will the judge think you should have done under similar circumstances. In performing the duties, the director can rely on opinions, reports, and statements of experts. That's why we reach out to attorneys for legal opinions. It's why we reach out to the landscaper and the arborist for written opinions. It's why we reach out to any number of experts for their written opinions, because we want to say, look, we acted consistently with our obligation as a director in doing our duty of inquiry, and we asked the expert, and they told us to do this, so we did it. A person who performs the duties of a director in accordance with the above shall have no personal liability based on an alleged duty, based on the duty of their failure to discharge the obligations. That means that even though somebody becomes unhappy with the association and sues the 5 directors, David, Sharon, Kay, Lori, and Carol personally, that after about 6 months, those parties are changed and the capital A association is substituted in their place. Okay, I'm going to take this second to ask a couple questions, and then we'll remember we were talking about California law and its relationship with the statute. We've been talking about the statutes now. What can a lone board member do? Oh, well, let's start with the first one up. If Mark H, if a board ignores many of their responsibilities like collecting funds, maintaining the common areas, enforcing the governing documents, is there a way to hold them accountable besides going to court? Well, the primary thought is that you recall the board of directors and you ask them, don't serve anymore if you're not going to do your job. So you try to get the other members to recognize, hey, the board's not doing their job, and you do a 5% petition and you recall the board of directors. If that doesn't work, then you try to replace them at the next election. Sometimes it's hard based on the voting rules. Sometimes it's hard to replace the directors. Joanne Jen Kirby, I'm just going to ask you to go ahead and mute your phone. So what can a lone board member do if he or she believes that the association attorney is giving bad advice or ethically improper advice in providing a response to the liking of the board majority? Well, obviously the attorney shouldn't give them whatever the majority wants to do. But as a practicing HOA attorney, I'm going to try and word this carefully. It's our job to help the majority of the board. It's our job to help the corporation. We represent the corporation, which is whatever is a majority of the board. And if our client corporation says, hey, we want to do X, it's our job to find a way to help that corporation do X legally. Obviously, if we can't get from here to there, we need to tell them and advise them and say, hey, we can't get you from here to there. But if the corporation, the 3 out of 5, the 4 out of 7 think that, hey, we want to go to Y, then we have to, that's our job. We're hired to help them get to Y. Do the courts often side with the HOA as volunteers? Can't be expected to do what's required or know what's going on. I'm just a volunteer and I don't have time. They do. There was a fabulous case 2 years ago in Palm Springs where I will swear up and down that the board member did far more than fail to exercise their fiduciary duty, did far more than fail to do reasonable inquiry. In fact, circumvented the board of directors altogether and went out and did their own thing and incurred thousands of dollars to the association, and they still didn't find them in breach of fiduciary duty. So yes, the standard that you're held to is very low. Is it legal to have rules like no skateboarding? I'm not 55, we're going to get to rules. But if the board approved, okay, so these are very specific items. Let's move on to the next slide. So anytime that we as attorneys write letters on behalf of the association, you're almost always going to see the NARSTAT case. We're talking now, we're transitioning from the statute, and we're now looking at case law interpreting the statute. All right. So we know that we just read the statute that says that the court should interpret CC&R restrictions in a manner to help the association operate and exist, right? So here's the case. Homeowner has, it's called NARSTAT versus Lakeside Village. It's a little association down in San Diego. NARSTAT owns 2 or 3 little cats. They're inside the unit. They never come out of the unit. Somehow the board of directors learns that she has cats. CC&Rs prohibit cats. And the owner sues the association and says, look, this is a ridiculous restriction. Nobody on the world sees my little cats. It doesn't affect anybody. It's an unreasonable restriction. And the next slide, court upholds the decision. Court ruled the CC&Rs are presumed to be enforceable unless the owner demonstrates the restriction and that the restriction is unreasonable. And we'll talk about what these are. And this shadows Civil Code section 5975. So we are going to uphold a CC&R unless it violates a public policy. So we're going to see situations where 1920s, 1918 CC&Rs preclude people from being members of an association because they're Jewish or they're, people of color, or whatever. We know that that's a public policy. It's absolutely unreasonable and we can't enforce it and would never want to enforce it, right? So a CC&R will be upheld unless it violates public policy. A CC&R will be upheld unless it bears no rational relationship to the protection, preservation, or purposes of the property. So a situation there was where the condo association came in and started telling an owner how they were supposed to maintain the inside of their unit. That is, you're a pack rat. We're afraid that this may create a fire problem. So we want you to start cleaning up your unit. And the association or the courts basically threw the association out on their butts and said, no, your restrictions bear no relationship to the purpose of the property. A man's home is his castle, and these people should be allowed to do what they want inside their unit. If a CC&R bears or imposes burdens that are so disproportionate to the restrictions benefit, they will not be enforced. That's a longer conversation. It happens rarely enough. Don't worry about it. Next slide. So the court recognizes CC&Rs give the board considerable power and authority to enforce their written restrictions, but they want the ability to second guess what might be abuses of those CC&Rs, right? And those are situations. The most common situation is what we call, and this is the language from NARSTAT, when the board is acting in good faith, not in an arbitrary or capricious manner, and its enforcement procedures fairly and uniformly applied. So the word uniform is actually in 3 places in this reading. So an association CC&Rs are going to be enforceable unless they're not arbitrary, meaning they don't pick out individuals, unless they're not capricious, meaning that they don't enforce against specific individuals, and are fairly and uniform applied, meaning that you don't just pick out certain people. All of this is saying the same thing. You can't enforce against Bob if everybody else is violating the same rule. And so oftentimes you'll see a situation where people say, hey, we need to enforce no towels on the balconies because the towels burn through the maintenance of the handrails and that kind of stuff. They burn through the paint and the moisture and everything. It ruins everything. So we need to have no towels. That's great. Enforce against one set of homeowners, but we're going to, Association of Legal Counsel, going to come back and make sure that the board of directors is not doing the same thing, right? Because if we go to court and the board of directors is doing that, well, then it's not going to be fairly and uniformly applied, and the association is going to lose. Next slide. So CC&Rs are presumed to be enforceable. They protect an owner's general expectations that when they buy into a community, we're going to be able to operate in accordance with the CC&Rs. So the pet situation, civil code after NARSTAT, civil code 4715 came in and said, well, we're going to give you at least one pet. There's a general legislative decision or determination that the world needs pets for mental and protection. And so we're going to allow one pet. So that was a change that was sponsored by PETA in order to kind of overcome NARSTAT. The point is that we generally follow the CC&Rs. We generally aim for fair and uniform enforcement. Next paragraph. Next slide. Okay, Lori, this is where you're going to take over. This is association maintenance. So before Lori starts, let's just close one chapter and start a new chapter. What I did was go through primacy of law, federal over state, over municipal, over HOA, and talked about how the Davis-Sterling Act operates with CC&Rs, sometimes overruling CC&Rs in situations where the legislature wants a very black and white rule for everybody, and sometimes reaching down to the CC&Rs in situations where the legislature wants to honor the original form and intent of the CC&R language, however poorly or well that's written. And then we talked about California law, right? And how it interplays with the decisions made by the judges, and how we look at California law and how that is modified by the case law, and how we as attorneys then try to guide our corporations, these nonprofit mutual benefit associations, in interpreting and operating within the confines of the law and the CC&Rs. Lori is going to take you to the job of the association. The job of the association is to maintain, repair, and replace the common area. Lori is going to talk about that. Go ahead, Lori.
Thanks, Mark. Just a reminder, I'm seeing some great questions in the chat as we go along, and I think the intent of the presentation is to have most of those addressed in the breakout rooms, which will be right after and between each presentation. So we'd be happy to answer these great questions. So if you can please ask us in the breakout rooms, that would be great, and we'll love to get to those. So as Mark was saying, some of the statutes, we're going to be heading into kind of maintenance responsibilities, because I imagine that all of you encounter maintenance questions and issues probably more often than questions on other parts of the CC&Rs. So in order to do maintenance, of course, you have to have the funds available to perform your obligations. So this statute is just reminding board members that the association shall, it's an obligation to levy regular and special assessments sufficient to perform your obligations under the governing documents and the Davis-Sterling Act. So this is a reminder to, look at your budget as you're to be doing, not only on a monthly basis, but on the yearly basis, to ensure that you're able to perform the maintenance obligations that you need to do. Do remember that each of your associations is, the main purpose is to preserve, protect, maintain, and enhance the property values and its appearance. So you cannot do that without having some sufficient budget to operate under. So Connor, next slide, please. As many board members have learned over time, the reserve funding plan shall also include dates and amounts of any changes in regular assessments. And if the board determines that an assessment increase is necessary to fund the reserve funding plan, any increase shall be approved. So not only do you have to pay attention to regular assessments that are going to be allow you as a board to fulfill your maintenance obligations, you also need the reserves. You need to be striving toward, funding those reserves so as to be able to perform the eventual repair and replacement of the common area. Many of you may ask, well, gosh, do we have to fund the reserves to a certain percentage? There's no California law currently that requires you to fund it to a certain percentage. But if you don't have sufficient funds, both to allow yourself to operate, in addition to reserves being set aside, a challenging owner could make some arguments that that is a breach of fiduciary duty. So these are just reminders that there are statutes that require the board to take a serious concern with financial status of the association to allow it to perform its obligations. Next slide, Connor. So going into maintenance responsibility, there is a statute, of course, that guides us on what the maintenance obligations are. Just a quick reference to the question in the chat earlier. This statute applies to both planned developments that consist of lots and condominiums, which have exclusive use common area. So, of course, condominiums are the only type of arrangement that tend to have exclusive use common area. But the first two, the common area and separate interest, apply to all types of property ownership. So the Civil Code, section 4775, says, unless otherwise provided in those CC&Rs, the association maintains, repairs, and replaces the common area. Owners maintain and replace and repair their separate interest, which is their condominium unit or their lot. And if it's a condominium, if you have exclusive use common area, such as a patio, a garage space, sometimes a balcony, a deck, unless your governing documents specifically provide otherwise, the owner maintains those exclusive use common areas and the association repairs and replaces. So provides a general framework, right? And so we're going to get into some cases in a few minutes that have questioned and interpreted the maintenance responsibility. What is often asked is, well, gosh, what is maintenance versus minor repairs? How extensive is maintenance, going to be interpreted? There are going to be various opinions on this, but general maintenance is usually, most people will agree, most attorneys will agree, that maintenance means, sweeping, cleaning, keeping free of chips on the surface of the balcony, not having any sort of damage that's being caused to the balcony. So a general maintenance responsibility is, again, it's going to be a fairly limited responsibility. If you take, for instance, the balcony as an example, an owner would sweep and keep debris off the balcony, not damage the balcony surface. But if something occurs to the balcony itself, such as the structural aspects or the railings themselves, then the association is generally the party who repairs and replaces the structural aspect of that exclusive use common area. Do remember that condominiums typically will be defined as the airspace within those areas and not the actual structure itself. Of course, there are going to be some exceptions depending on what your CC&Rs say. Sometimes an owner will be responsible to, for instance, to paint and maintain the actual surface of the balcony. That could be the surface that is a tile surface that the owner has added, of course, on top of that balcony. So again, it's hard to be specific without delving into your specific CC&Rs, but these general principles should at least sound familiar or become familiar when you are determining, okay, who is responsible and how are we going to approach this maintenance responsibility. Next slide, please, Connor. So this is a diagram of a typical condominium, although I know Mark found this and it has underground heated parking. I don't think that that's typical in Southern California, but this is the typical layout. So when we talk about patios, that's going to typically be defined as an exclusive use area. The interior of the unit, the interior airspace, of course, is going to be the owner's outdoor living area that is similarly treated usually as an exclusive use common area. So what we tend to see in maintenance questions is where the intersection of the common area and the unit come into play. Here's a good example: pipes and utilities. Many CC&Rs and condominium plans will only make the owner responsible for the pipe or utility that comes into that interior airspace. And you will typically see this language when it says the outlets of the pipe or the gas line or whatever is coming into the interior of your unit, that the owner is responsible for that. But anything outside of that airspace becomes the association's responsibility. That's one example of typical condominium type CC&Rs. Another example, however, is where the condo plan and or the CC&Rs will say that the owner is responsible for pipes and utilities that serve their single unit, no matter where located. So even though a pipe might be the outside of the actual airspace of the unit in that instance, if your documents say something to the effect of no matter where the pipe or utility is located, you as an owner could be responsible for that utility, even though it's outside the airspace. So again, this is just an example of where the interplay between that statute that I said, that unless the governing documents provide otherwise, it really does take often an attorney to interpret, especially older governing documents, and look at the condo plan and look at exactly how everything is worded to determine who's going to be responsible and where that division of responsibility comes into play. We will be getting in a few minutes to an example of a maintenance matrix or chart that is often very helpful to try to guide managers and owners and board members on who is responsible. Next slide, please, Connor. So let's get into one case that is one of the primary cases that you will hear about governing maintenance. Now, you've already heard the business judgment rule that Mark went over about how board members are to make decisions. So this case was a case in which the court was looking at how board members, what is the standard by which board members are to make decisions. So we have that business judgment rule sitting out there, but how is that going to come into play when we have a decision that a board is making as far as how to maintain its common area? Well, this is the Lambton versus La Jolla Shores Club Dominium Homeowners Association. It's a pretty cool name, being a club dominium rather than just any old condominium, right? So that really jumps out at you. So the facts are that the owner experienced some interior damage to her condominium due to termite and damage and some dry rot. This owner wanted the board to tent or fumigate the building instead of just spot treating for termites. She felt that that wouldn't be good enough if you just spray for termites. She wanted the whole building tented. Any of you who've been through a termite tenting know there's a lot of complications, right? Especially where you have multiple owners within one building. Generally, if you fumigate the building, everyone has to vacate. You have to pack up your food and your medicine and your pets and your plants, right? So there's a lot involved. So this board of directors looked at all the options. They did their reasonable investigation, like you would imagine under the business judgment rule. They investigated, saying, what are the pros and cons of if we fumigate versus spot treat? Well, this board decided we're going to go for the spot treatment. This is because there were costs, right, involved in tenting. It's much more expensive also. The logistics of relocating owners and having them vacate the building. Concerns over potential residue from fumigation, right? A lot of the gases that are used, people get concerned about that and the long-term impact, even though it dissipates after the tenting. Pet moving expenses, right? Potential damage to the roof or building. When they put the tent on, someone has to usually walk on the building and secure all the materials. Potential loss of rental income, right? If tenants had to move out, owners would be losing some of that rental income. And the fact that fumigation doesn't entirely, prevent future termite damage. So this board, after weighing all the pros and cons, they opted for a spot treatment. Well, the owner still wasn't happy and sued the association, claiming that her unit was going down in value and for the damage that would occur if the board chose to spot treat. Next slide, Connor, please. So the Lambton court looked at the business judgment rule, but they kind of came up with a special rule of judicial deference regarding maintenance decisions. And they said wherever a duly constituted, community association board, as long as they performed a reasonable investigation, made a decision in good faith in regard to what they believe to be in the best interest of the association and its members, and where they exercise that discretion in its decision within the scope of its authority, among its CC&Rs and the law, they get to select among the means for discharging their obligation to maintain and repair the common area. And if they do that, the court is going to defer to the board's authority and presumed expertise. So the court is basically telling us here that they're not going to second guess the board's decision in this matter. They're going to look at it and make sure that the board met the standard of care, meaning did they investigate it? Did they have a good basis for their decisions? But the court's not going to jump in and become a decision maker, is what we're being told here. So this is good news in that the board has, each community is different, right? So the board's going to have that discretion to determine how to maintain their common area. Now, sometimes you'll see in CC&Rs standards like the board shall maintain it in a first-class manner, or shall maintain the common area in a clean, operative, or operable, attractive manner. I mean, those are kind of given standards. So sometimes you'll see that, but again, if the board determines that it needs to replant some trees versus not replanting some trees, a court's not going to jump in and say, no, you only really should have replanted one tree. They're not going to be that specific. The court's only going to review any decisions that are challenged to make sure this standard is being met. So this is kind of the business judgment rule, if you will, for maintenance decisions. Next slide, please, Connor. So why is this case important? Well, again, it prevents second guessing of board's decisions. It provides some guidance as to how decision-making is going to be looked at with respect to the common area. It protects board members against individual liability, at least, provided that the standards for reasoned decision-making are followed. Now, again, that doesn't prevent an owner from filing a lawsuit saying the association, the board, made a bad decision, right? We all know that that's possible. But And then it's consistent with the Nardstedt case that Mark talked about, because we're upholding those decisions if they're made in good faith and if they're consistent with the CC&Rs and they're not somehow against public policy. So this is why it's a very important case, and it helps the board know that every time someone's not watching their back and questioning that decision, as long as they're following the standards. Next slide, Connor, please. So let's look at another case that also had to do with maintenance. Now, this is the FN versus Portofino case. So here, the owners had a vacation condominium at which they would come a few weeks at a time and want to enjoy their vacation. Well, this condominium association, they had a sewage backup occur in their particular unit 9 times in 6 years. It doesn't sound like much of a vacation, right? So each time when this occurred, the owners reported these incidents to the property manager and at least one board member. Now, the manager at that time did handle some limited types of maintenance. They had the lines snaked, hydrojetted. The board was aware of these things. They said, basically, let's try this. But they only kind of handled these as they came up. So each time the sewer backup happened, yes, they responded, but it was evident right after a number of times that this was not a long-term solution. And unfortunately, the owner kept incurring, substantial damage inside the unit, as you would imagine. So the efforts that were being made while they were, there was something being tried, they weren't correcting the problem ultimately. So the backups continued. However, the board and/or management at that time didn't really look for a continuing solution, or maybe consult additional professionals to say, is there anything else we should be doing? So they didn't really do a reasonable investigation to correct the recurring problem. Next slide, Connor. So as we saw in the Landon case, the board had investigated and done its due diligence, right? Here, the owner sued the association saying, nope, the board has breached its CC&Rs, it's been negligent, breach of duty, and those types of claims were made. So the owner in this litigation had a plumbing expert that showed that had a more reasonable and diligent investigation been done, they would have discovered that there was debris built up in the main line, the sewer line, for over 10 years, that the lines had never been cleared properly. The expert in that case testified that kind of a rotor-rooter, if you will, should have been used, and a camera could have been used that would have apparently cleared the lines and caused the problem to be remedied. So there were other remedies available that just weren't pursued. And the association, on the other hand, said, well, we attempted to clear the lines. We should be given judicial deference, right? Similar to the Lambton case. We made the decision, we tried. Well, that wasn't quite good enough. Next slide, Connor. So the court says the association has the burden of proof to demonstrate this defense of judicial deference. They're going to have to show that they met these standards for decision-making. And the court came back and said, the judicial deference doctrine does not insulate or create a blanket of immunity where the board ignored or failed to make effective decisions to fix the sewer line problem over a period of many years, despite having knowledge each time that this was a recurring problem that was not going away. So because there was really no reasonable investigation, there really was no decision-making process that the court found that was adequate. And management was not obviously a board, so they weren't entitled to judicial deference like a board of directors would be. So there was some liability on the part of management, unfortunately, too. Next slide, Connor. So why is this case important? If you look at the picture, the board may not ignore problems and fail to make decisions, which is the head in sand approach, right? A reasoned decision-making is going to be required. So even if this board in the Afan case, if they had done more of an investigation and made more attempts, sought expert, or professional input, and tried different things, and maybe the court would have found differently, but they didn't do that here. So a reasoned decision can include a decision after reasonable investigation not to take further action. Here's another example of that. Sometimes you will, of course, be reported that a homeowner's in violation, right? and you investigate the violation, and after a reasonable investigation, if you decide that no further enforcement action is needed against someone, that decision is going to be upheld. Let's say someone has been having repeated parties, but then they actually start abiding by the CC&Rs. There's really no reason to take further enforcement action at that point. Another example would be a tree that is in the common area. If even though a homeowner may say, "Oh, I want this tree removed. I don't like it. It's causing issues," and the association, let's say, consults its landscaper, an arborist, and the arborist says there's nothing wrong with this tree. It can be trimmed, but it doesn't need to be removed, for instance. The board, as long as it's made a reasoned decision, can decide reasonably, well, we're not going to remove that tree, or we're not going to take further action. So there's various many examples, right, we can come up with, but the bottom line is, as long as you make a reasoned decision, even if it's deciding not to take action, as long as you're able to show to a court or arbitrator or mediator that we looked into the problem, we discussed it, we inquired, we made a decision in good faith, and we thought was in the best interest of the association. Even if someone says later on, well, hindsight's 2020, we could have made a different decision, generally the court's going to uphold that as long as it's a reasoned, informed decision. Next slide, Connor. So what we were talking about earlier is a maintenance matrix. This is something that can be prepared by your attorneys, and it's a helpful tool that will sometimes, hopefully, reduce legal fees and questions as far as who's responsible for this pipe or this exterior door or this item. Many association attorneys, have done these, and so it's a very valuable tool that's been found. So if you don't have a maintenance matrix, this is something you may want to look into. And of course, it takes really a line-by-line analysis of not only your CC&Rs, but your condominium plan if you're a condominium property, sometimes a tract map for your individual homes. Also, it's a line-by-line analysis that needs to be done before this chart is put in place, in addition to analyzing the civil code providing for maintenance responsibilities. But it is a valuable tool, so I encourage you to check with your attorney on that. Next slide, please, Connor. So let's get into an example, just so that this kind of, you can apply some of these principles to an example. So let's say a roof leak occurs, and we're speaking of a condominium property at this time. A roof leak occurs during a large rain, causing water to leak into an owner's unit and causes interior damage to carpet and flooring. I'm sure this sounds familiar and has happened. So an owner will report this and wants the association to install a whole new roof on top of their property instead of patching or repairing the location of the leak. And let's say this board obtains bids and advice from roofing experts saying, well, what is the right thing to do here? What do we need to do to correct this problem? And an opinion is rendered by that roofing expert that the entire replacement is not required or necessary. Okay, so the board here has learned of the problem. Once they have knowledge of an issue, they're going to do some investigation, including consulting a roof expert, right? Because you and I know, attorneys, board members, we aren't roof experts. So who's going to be responsible to repair the roof in this situation? Well, the association is generally going to be responsible because of that statute. Unless the CC&Rs provide otherwise, the association maintains, repairs the common area. So we know we the association, need to repair the roof. Who decides whether to perform a spot repair versus replacing the entire roof? Well, as we have learned, the association, generally under most CC&Rs, right, is going to have the responsibility and discretion to determine how and in what manner to correct this issue with the common area roof. So the board has the discretion under the Lambden case that we just talked about to decide the ordinary maintenance decisions with respect to the roof in good faith and with reasonable investigation, and what they believe to be in the best interest of the association and within the scope of its authority under the CC&Rs. As Mark pointed out earlier, the Corporations Code allows boards to rely on experts' opinions. So the board is correct in reaching out to the roof expert saying, what do we do here? So the bottom line is the association gets to decide, well, do we need a spot repair, repair just this area of the roof that leaked, or do we need to replace the entire roof? Just because an owner is asking for something, which, there may be a basis for the owner asking, saying, we don't want any more problems, just replace the whole roof. Well, it may not be time to replace the whole roof. And it's obviously not necessary in this particular example because the roof expert has said it's not time to replace the whole roof. So the association gets to decide. Who repairs the interior of the unit? Well, again, we defer back to our civil code section. Unless the CC&Rs provide otherwise, the owner is going to maintain, repair the interior of their unit. Now you may ask, well, gosh, the roof was the cause of this. Why should the owner be responsible? The general principle remains that association still fixes the common area and owner still fixes the interior, even if, and regardless of the cause of the damage, even though it originated from the common area roof. Now, the exception is if the owner can show that the association was negligent in its maintenance of the roof, then yes, we may be able to say that the association is going to have to pay for that interior damage. The fact that damage occurs is not a proof that the association was somehow negligent, right? If the roof has been kept and maintained in a reasonable manner, the fact that you have a big rain that causes a leak, that does not mean that the owner can automatically prove negligence. But if the association can show maybe that the roofs have been in bad shape for a while and that leaks have occurred throughout the project and really haven't been addressed, then the owner may be able to build a case that the association knew about this and failed to use reasonable care in the maintenance of its roof so as to cause that interior damage. So again, the general principle is association maintains common area, owner maintains that interior, but the exception is if the owner can show negligence. Now, how may insurance come into play? The association, of course, may have insurance coverage, and that may cover certain interior items that would not otherwise normally be the owner's responsibility. So do keep in mind that regardless of what your CC&R is saying, who maintains which component, insurance is not a perfect fit onto that matches with those responsibilities. Often insurance will cover things that are in the interior up to original construction even, meaning they will replace cabinets that might have been damaged or carpet. So this is really going to be specific, of course, on your insurance coverage. You've probably heard of bare walls type coverage that does not include some interior items, and then a full replacement coverage, which may include interior items. So I don't want to get too deep into insurance, but insurance may change how this is applied is the bottom line. So regardless of fault, if the association's insurance covers those items in the interior, the owner will be entitled to make an insurance claim. Because owners pay those assessments and because your assessments are used toward insurance premiums, the owner will have the right to the use of that insurance if there is coverage. Again, there's going to be some deductibles that come into play. So, again, with that's probably a whole nother seminar is how insurance would apply. But this is an example at this point of how the maintenance statute and your CC&Rs are going to come into play in a real life example. Next slide. Or David, did you want to jump in?
Thanks, David. Good morning, everyone. For this portion of today's presentation, I'm going to talk about some cases, some case law and how they can be useful in enforcing the association's rules and regulations. I'll specifically be talking about some cases that involve enforcement of architectural rules, a couple of cases regarding protection of views, which I think is kind of interesting, rental restrictions, which actually came up during our breakout session, questions about rental restrictions. And then I'll also be talking about some cases regarding use restrictions and also nuisances. So I have a number of cases to get through. So I apologize if I don't get to the questions that are in the chat box. I look forward to speaking with you during the breakout session if you have questions. Next slide. All right, so case law is important for helping boards and associations regulate or impose rules, not just adopting rules, but also enforcing them. Many times the CC&Rs have vague or broad language, and that's almost on purpose, because putting the detailed information in an association CC&Rs could often get outdated quickly. And as many of you know, amending CC&Rs is a long and expensive process. And this is why many times it is our recommendation for associations to adopt operating rules, to lay out the details, adopt architectural guidelines that can be amended by the board and with membership review. What Lori talked about, a maintenance matrix that provides specific detail about certain components and who's responsible for what. Because if this is in the CC&Rs and your CC&Rs are super detailed, if you want to make a change, you have to go through a much bigger process with legal counsel ballots being mailed out. Case law is important. If you ever you have access to it, you have ECHO, and there are publications out there that announce when certain cases come out, so you will be able to see what these cases are about. But sometimes these cases are not even in your jurisdiction, and they're not technically not what we call citable or unpublished. But regardless, cases are helpful, not just because some of them are treated as precedents, but they even have the court's reasoning or dicta, which is what the court's, not the main holding of the case, but just other comments that are made by the judge in the opinion. That's helpful for applying these vague or ambiguous rules to your specific situation. The case law also helps homeowners and boards understand the boundaries of these rules, because a lot of times these published cases are about those people pushing the boundaries of certain rules. You know, what does a commercial use mean? What does a short-term rental mean? What can or can't an association or a board do? A lot of this is discussed in cases and based on those specific facts, which you can then apply to your association or your certain situation, and then compare and see if your situation is more like this case or more like that case. So the understanding case law is helpful in that regard. Next slide. So the first one I wanted to talk about is Dolan King versus Rancho Santa Fe Association. It has pretty interesting facts, but it's also useful not just for architectural guidelines, which is what this case talks about, but just also how the court again cites to a couple of the cases that were mentioned by Mark and Lori earlier, the Narstead case and the Lambden case. And those are, cases that if you're not familiar, you should familiarize yourself with, because many cases in community association law cite to those cases. So this is a case from 2000, a case from San Diego County, where a homeowner sued the association, the board, and an art jury, which is like a committee. So the architectural application that was submitted by the homeowners were for additions to their home and a perimeter fence, and it was denied. So they wanted the court to declare that the association's actions were invalid. But to better understand the situation, you have to understand this Rancho Santa Fe community. They had a covenant. They were subject to a covenant that was recorded in 1928. And it went on to describe this community as an unusually attractive and valuable as a high-class place of residence because of the rare quality of its landscape, trees and shrubs, and the fine architecture and other improvements established by its property owners. So they took a lot of pride in the aesthetics of the community. They had an art jury, and part of the association's process was for architectural applications to be approved by this art jury. And they had specifications. The art jury had design guidelines that specified in detail the types of materials that can be installed. These guidelines prohibited things like, fake wood materials. It had to be, if it had the wood look, it had to be actually real wood. And then it had, and these are guidelines that are not in the CC&Rs. These are, adopted guidelines. So the guidelines also specified the architecture, the type of architecture for certain types of plans, like this. This home at issue is a type 1 plan, which is basically a Mediterranean style home with inspiration from Latin types of other similar, which developed under similar climatic conditions along the Mediterraneans. So it was basically Mediterranean style homes. And these homeowners wanted to add some rooms and change the exterior to add turret style additions, if you guys know what that is. But their architect basically said this is, Spanish revival type design. They originally had a 3-rail corral type fence around the property. They wanted to change it to stucco with pillars and columns, which sounds very expensive and sounds really nice, but the art jury felt this didn't match the architectural guidelines for that type of home. So the application was denied. So in this case, the judge sided with the association and the art jury. They cited to the Narstead case and the Lambden case, and they basically said that restrictions on the use of properties and covenants are presumed to be reasonable. They deferred to the CC&Rs, which they believe protects the general expectations of owners. And that restrictions, the court said that restrictions are evaluated for reasonableness in light of the restrictions' effect on the project as a whole, and just not from the perspective of the individual homeowner. So there's some good tidbits from the case that applies to a lot of actions that the association might do in enforcing things like design guidelines, but also this case is important for just in general enforcing preferences that the board may adopt in something like an operating rule, a maintenance matrix, or a design guideline. Right, next case. So there's a couple of cases here that relate to protection of views. We're taught, so these are two main cases, Boxer versus City of Beverly Hills, which is a case that was brought by homeowners who live on Spalding Drive in Beverly Hills, who sued the city of Los Angeles for planting redwood trees, sequoia trees to be exact, in 1981, and in 2005, they filed this lawsuit for basically the city blocking their views of the Hollywood Hills. They had a view of the Hollywood sign and Griffith Observatory. And so in this case, the court made clear that landowners have no natural right to an unobstructed view. And that's the case that's often cited whenever homeowners may complain about certain improvements that an association approves, which may block their view. And then Posey versus Leavitt basically says, even though homeowners don't naturally have a right to a view, It's something that can be included in an association CC&Rs. So this one, it's not dicta, but it's part of what the court was talking about in Posey versus Leave It. The CC&Rs did not have a view protection provision, but it basically made clear that you can have one. So it's something that's a lot of associations, coastal regions, certain that have decided they want to include that. And if it's in a recorded covenant, then it's an enforceable right. Next slide. All right, rental and lease restrictions. So I'm going to talk about a few cases that talk about short-term rentals because it's it came up in our breakout room. It's a topic that will continue to be a hot topic as it relates to rentals. These cases talk about the single family home restriction, commercial activity, and how short-term rentals are enforced. So Colony Hill versus Gamadi, this is a case where a San Diego association sued a homeowner for breach of the CC&Rs. So in 2000, this homeowner, his name is Gamadi, he owned a 4-bedroom, 3-bathroom home in Colony Hill, the association, and he would rent it for periods between 2 months and 2 years. So he was renting the rooms. They called him a serial room renter. The association gave him notice in 2002 after he, a couple of years of him doing this rental arrangement, said that he was in violation of the CC&Rs, specifically the single family dwelling restriction, that these are single family homes. So it has to be one family unit to live in these homes. So Gamadi argued that these renters, he considers them as family. And it was established, I think one of the renters was his cousin, but the rest of them, they not related. And it's renters that he got through ads in the newspapers or oral verbal agreements with these renters. So the board found that renting or leasing to multiple occupants constitutes a commercial enterprise and not allowed under their CC&Rs. He was required in the court to prove that the single family dwelling use restriction is arbitrary and that is not substantially more burdensome than beneficial to the affected properties, and that it violates fundamental public policy. The court found that this arrangement, the payment and share of utilities, did not constitute a group into a unified whole. So they sided with the association. The court held that Gamadi violated the restriction limiting the home's use to single family dwelling purposes. And the court again talked about preserving and enforcing written instruments like the CC&Rs that embodies the expectations of the parties rather than treat them as what they call worthless paper. So they will defer to what is stated in the CC&Rs. Next slide. Oh. Sorry, can you go back one more? Sorry. All right, I forgot to talk about Watts versus Shores before we talk about the next slide. Watts versus Shores is another short-term rental case, but it talks specifically about the fees that may be imposed on the homeowners who rent their homes on a short-term basis. So this association is in San Luis Obispo County, and they challenged, and a homeowner challenged the fees that were adopted by the association. It's a single family home community. It consists of 851 parcels, and most of the units are rented out, and 66 of those homes were absentee homeowners, meaning that they don't live there, and they were regularly renting them to short-term vacation renters. So one of those homeowners sued the association because they had a rule that's saying that the minimum rental period is 7 days, and those people renting out their homes on a short-term rental basis has to pay an annual fee of $325. And so they also had a rule that limits the number of automobiles and boats and other watercraft that renters are allowed to bring in. They had a mandatory garbage collection fee, a boat and watercraft fee, building permit fees, and then property transfer fees. So what was key in this association is that the dollar amount that they were charging is not some arbitrary amount that the board came up with. They had their general manager, the association's manager, testify that based on his discussion with the board, member staff, code enforcement officers, and other information, that short-term renters cause more problems than owners or their guests. And the problems include problems with parking, lack of awareness of the rules, the noise and use and abuse of the facilities. He also said that there's other, just these are specific problems that come with short-term renters and not the usual long-term renters. So this fee that they charged was related to the cost, basically the burden on the association for having these short-term renters use the property. And the court held that associations may adopt reasonable rules and impose fees on members relating to short-term rentals of condominium units. But it had to be tied to an actual cost and not just some punitive fine, basically, against those homeowners who choose to rent their home that way. The court relied again on Lambden and Narstead, and they said that the courts will uphold decisions made by the governing board, and as long as they're consistent with the governing documents and public policy. So that's Watts. Next slide. So Brown versus Montage at Mission Hills is an important case. It was it's a ruling that came down last year and made basically confirmed that restrictions or minimum lease rentals restrictions are prohibitions on rentals, and that the grandfather clause applies to it. So what that means is, well, let's back up. Let's talk about this. So this is an association that in 2018 prohibited short-term rentals that were less than 30 days. In this case, the owner of the unit, the owner had owned the unit since 2002 before this, this new restriction was put into place. And the owner had been doing short-term rentals and argued that they should be allowed to do short-term rentals. The homeowners association argued and said that the association can impose this new rule, this ban on short-term rentals, and that the grandfathering clause that under the civil code, basically if a homeowners association adopts a new rental restriction that prohibits rentals, it wouldn't apply to the current homeowners. The association argued this is not a prohibition on rentals because you're still allowed to rent your home. You just need to do it for terms longer than 30 days. The court disagreed with that, which is interesting to many in this industry, many law firms, because many argued that a prohibition on short-term rentals is not a prohibition on rentals in general and wouldn't be subject to like the grandfathering. This case, basically after this case was adopted, associations now, if they do adopt a new restriction on short-term rentals, it exempts the current homeowners from that new restriction. It would apply to new homeowners who buy into the property, but not the current. So if a person bought into a development and they had the right to do short-term rentals, the association can't take that away from them, is what this new law says. I put a couple of unpublished cases here. And again, unpublished cases means in the legal world, we can't use them in our pleadings or argue them to the judge when we're saying the association did the appropriate thing here. But they're useful. Sometimes you will see them, online articles about what a court did, a local court did, not in your jurisdiction, but they're helpful in seeing what the reasoning was behind the court's decision. So these are a couple of, just to illustrate how courts have come down differently on the same issues. We have a couple of cases that says short-term rentals. One says it's not a commercial use, and then another one that says, yes, it is a commercial use and not residential. And that's just something to show you that there's different reasoning for it. And you would obviously work with your legal counsel and understand what's the case law in your specific jurisdiction that would apply to your situation. Next slide. So I have a few cases here related to use restrictions. The first one is called Biagini versus Hyde. And these are talking about the commercial, the restrictions in CC&Rs that prohibit commercial use, or restrictions that says homes shall be used only for residential purposes or single family home residential purposes. So in Biagini, this is a case out of the city of Sunnyvale, where a woman bought a property with her husband in a subdivision that had CC&Rs that says specifically that no lot shall be used except for residential purposes. She had, in this case, she had spoken to the subdivider when she purchased her home and talked about how she intended to open a beauty parlor in her residence. And in the case, she talked about how she only had about 6 customers per day. She didn't have any signs. She didn't impose any burden or inconvenience to the neighbors by having this business. And but nevertheless, the court found that these activities constituted commercial use that are detrimental to the association and the other neighbors, and that it was proper for the association to prohibit this activity as a commercial use. The court said that restrictive covenants will be construed strictly against the person seeking to enforce them and in favor of those encumbered by the use of the property. But one of the court's functions was to construe the restrictions for the purpose and determining the language based on the intent of the parties. In this case, the court found that it was the intent of the parties that these were only going to be used for homes and not for commercial purposes. And then another case on this, Lincoln.
Hello, Paul. This is Rod Thompson calling.
Another case is Lincoln Savings Association versus Riviera Estates. This one is not about a beauty parlor. This is about a driveway where the property owners, Lincoln Savings and Association, they owned a couple of lots in the neighboring association's property, but they did own a lot in this in Riviera Estates, and they were using that lot as a driveway to access the 2 properties in the neighboring lots. The court held that this is not the CC&Rs in this for this association basically said that these are the lots must be used for residential purposes, and that using it as a driveway, an empty lot as a driveway, is not consistent with the intention of the CC&Rs. So once again, the courts defer to what the CC&Rs say, even if there's no burden to others by your particular use of it. The next case is 8th versus Ketelholt, and this one is about a wine growing business, basically a vineyard on the property. And in this case, the court came down and said that wine growing is not a commercial use for this particular association. It's in the city, it's in Southern California. where the homeowners were cultivating a vineyard for the purpose of making wine sold to the public. But because the wine was being made and packaged somewhere else, they're basically just growing it, and it didn't impede on others' use of their property. This court said that it's not a business or commercial activity within the meaning of the CC&Rs. So in this case, the court found that the homeowners association board acted within its discretion and by allowing this vineyard. So it seems like these cases flip, or the courts flip flop on these cases sometimes, but it's really, as you can see, and as it emphasized in these cases, the courts defer a lot to the board's action, similar to the Narsted and Lambden cases that were discussed earlier today. Next slide, please. Just a couple of cases very briefly. And this, earlier I was talking about use restrictions like commercial versus residential use of the separate interest, the home. A couple of these cases I just thought I would throw in there. They're unpublished, but they talk about use restrictions, use of common area facilities, and the board's authority to impose rules on it. I think it's a good reminder. These are unpublished, and it happens to be one of the keys was an association that was represented by my firm. So it's very familiar, and we always talk about it internally. But the important thing is, even with these unpublished cases, is how the court views restrictions adopted by associations. So the Landesman versus the Keys had to do with an association that had multiple swimming pools and other recreational facilities, and the association prohibiting people under 18 years old from using one of the pools, and then children under 15 years old from using some of the gym equipment and things like that. The court said that there's no validity to the reasoning provided by the board for banning children from using the pools, just so that some homeowners can have peace and quiet and not have children there. Which is interesting. It's not, because we all know there are many hotels and other places that do have a children's pool and an adult pool, but they saw no correlation other than the association discriminating against children. But for rules like limiting the children's access to gym equipment, or requiring that children be supervised when they're using the tennis courts after certain hours, those were reasonably related to safety. And so they had no problem with that, but they did have a problem with the pool rule. And then Llanos versus Coelho, also an unpublished, and this is a federal decision. So it's in federal court, and the court looked at cases in different states, federal cases in different states. And they basically said that the association's rules that designated family pools and adult pools in the complex and prohibiting children from playing in and around adult areas as discriminatory. So similar to the Keys. These cases basically just remind boards, if you are considering adopting rules that special rules for children or people of a certain age, to consult with legal counsel to see if there is some kind of correlation, justification for adopting these rules, that so that you would not be in the same position as these cases where it says it was a discriminatory rule. Okay, hopefully I'm doing okay in time. I have a few cases, nuisances, starting with Haley versus Casa del Rey. And these cases basically help associations define what is an actionable nuisance. This one, Haley, is regarding a homeowners association where some homes were basically building out some of the oh, good, thank you. Some homes were building out their patios. So the first floor condominium homes basically expanded their patios out into unused common area space. And they were sued by some homeowners. They happened to be one of the homeowners that had the extended use, but they basically didn't like it because other homeowners were preventing them from walking into that space that they have now kind of claimed as part of their exclusive use common area. And there was a vote that was done. Eventually, a committee was formed and a vote was done to formalize this approval of the homeowners taking over that portion of it, expanding their exclusive use common area space. And one of the causes of action that was filed against the associations is for nuisance. Among other things, but the court here says that it's not an association it's not a nuisance for an association to amend their CC&Rs and allow encroachments. There may be other grounds for suing the association, but nuisance is not one of them when the association is trying to formalize something, even if you may not like it. Then there is Stell versus J. Hales development. And this one is, so J. Hales is was constructing a house in violation of some CC&Rs and and also some local zoning ordinances. So this focuses on the violation of the local zoning ordinances. So this law basically stands for the fact that a zoning violation can be grounds of a nuisance cause of action. So that's in addition to a lot of CC&Rs have a provision that says members must be in compliance with local laws, which is a grounds for it, but a nuisance cause of action may also be brought for a local zoning violation. The limitation to that, however, is that only it is a grounds for a nuisance cause of action, but only if there's a special injury to that person. So it's not just an automatic, the fact that they were in violation of a zoning ordinance. There has to be a showing that they were specifically injured by their action of violating the zoning ordinance. Next slide. Okay, so those are just some examples of cases that demonstrate what types of nuisances can be actionable. These two cases that I have up here show the defenses to nuisance cause of action, and those defenses include constructive notice and also assumption of risk. And these cases I thought was interesting, but they both deal with lawsuits against a golf course and golf balls, where it seems like the court came down differently in these two cases. So the first is the Hellman case. So in this case, the plaintiffs purchased their golf course in Santa Barbara years after the course had been constructed. And so they had, it was argued that they had constructive notice that they live right next to a golf course. The golf balls would be coming onto their property. So the homeowners argued they can't even use their patio. They're always afraid to get hit by the balls. They figured, and they were getting 5 to 10 golf balls per week. And so they sued the golf course on the grounds of nuisance. So the civil code defines nuisance as anything which is injurious to health or is indecent or offensive to the senses or an obstruction to the free use of property so as to interfere with a comfortable enjoyment of life or property. So the basic concept underlying the law of nuisance is that one should use one's own property so as not to injure another. So they felt this was, the homeowners felt this was clearly a nuisance. But in this case, the golf course said the homeowners had constructive notice. They knew they were subject to having the balls come into their property. So the court sided with the golf course and said that because the homeowners had constructive notice, there was no unreasonable invasion of free use and enjoyment of the property. The next, I think this is the last case I have actually, Curran versus Green Hills, also another golf case. But this basically limits the application of the assumption of risk defense. It says that the evidence must show that the injured party appreciated the specific danger involved. They must show that they have not only had general knowledge of the danger, but specific knowledge and appreciation of the particular danger. So in this case, the homeowner talked about, or the plaintiff homeowner talked about how they would use the pool only at certain times when the golf course was hardly used, and that they did certain things to make sure that they don't get hit by the ball, but then they did and got injured. And the golf course try to argue that they shouldn't be liable because of assumption of risk and also constructive notice. But the courts disagreed because they held that the doctrine of assumption of risk didn't bar the claim for injury from a golf ball because the homeowner only had general knowledge of the danger posed by the golf balls rather than specific awareness of particular dangers present at the time of when the injury occurred. So they were looking specifically at what the homeowner knew about the particular event that led to the injury. So again, these are things, a lot of times they will be what your legal counsel will be discussing with you and explaining whether or not the association has a good case or not, a good defense or not. And it's just something to show how rules, statutes, provisions in your CC&Rs and association rules are applied to actual facts that may be similar to what you're dealing with, and could be helpful in understanding how and to what extent that applies. All right, now I'm going to turn it over to Sharon to talk about First Amendment.
Morning, everyone. So I'm here to talk about the free speech in associations and common interest developments. This is tackling constitutional law. So I hope everybody's ready for that. We've covered a lot of material this morning, and this is not a simple area of law, but we're going to give it a go. So let's start with the next slide, the basics. As you already know, your First Amendment rights come from the First Amendment to the US Constitution, and that includes your right to free speech, right to free press, right to peaceably assemble and to petition the government. And this is the beginning of the Bill of Rights. But what you may not know is that the First Amendment is really about what protections we have as people from the government. So when you're in law school and you're looking at a constitutional case, the trick always is you might be presented with all these things where you can see that this is obviously impinging on somebody's free speech rights. But if it isn't state action, then it doesn't fall under the First Amendment to the US Constitution. So you have to have something going on that is the state, a government, or something that is associated with the government, funded by the government. And that is what you're dealing with in the First Amendment to the US Constitution. Now, the next slide you'll see is the California Constitution. The California Constitution contains free speech protections, and it's worded differently. So you see in the wording of the California Constitution, it doesn't start with what the government can and cannot do. It says every person may freely speak, write, and publish his or her sentiments, and so forth. So this is a difference in not only the language, but it has proven quite different in the way that the Constitution of California has been applied, because instead of just finding the constitutional protections apply from government action, the California Constitution has been applied in private settings so that it can apply and you can have free speech rights against private property owners. And of course, homeowners associations are private property owners. And so that brings us to how do we apply the constitutional rights within CIDs? So the next slide. The general rule is that when you are a private property owner, as a CID is, you can control what goes on your land, in your community. If you're a business, you can control what is said within your business. You hear a lot in the news about Elon Musk bringing free speech to Twitter. Well, Twitter is a private company. And so generally that's not about the First Amendment to the US Constitution, because Twitter is not a government. But if you start likening it to a government, and you probably have heard Twitter called a town square in some conversations, then you can start limiting what speech might go on, and you have more ability to claim constitutional rights if you're talking about a public square. So the general rule, remember, is that HOAs are private property. They do get to control what goes on there, but not so fast if we're talking about a context where you can call the association a mini government or a public square. The groundbreaking case on this area of law was in 1980. It's Pruneyard Shopping Center versus Robbins. And this is about the Pruneyard Shopping Center here in Campbell, California. Probably many of you are familiar with it. It's right in my neighborhood, since my firm's in Los Gatos. And the Pruneyard Shopping Center is just like any shopping center you might picture, that has outdoor plazas and places for people to gather, benches, gardens. And this group of students had set up a table and were passing out literature there and protesting something. And I believe the materials were anti-Semitic and particularly distasteful to the owner of the Pruneyard Shopping Center. And so the Pruneyard kicked these people out, kicked the students out of the shopping center. So you might think, well, that they should have the right to do that because that's private property, and that would have been the argument at the time, except in this case, the Supreme Court of California, and this went all the way up to the Supreme Court, found that in these days, in the 1970s and 80s, the shopping center is actually a public square, just like you might think of the public square, public park in the middle of a town, or the courtyard steps or something that's owned by the public entity. This is not owned by a public entity, but the court is treating it like a public entity and saying this is a public square, and therefore you cannot limit the speech of these people by just because you don't like it. And so they said that the Pruneyard was wrong to throw these students out, and they must allow the speech to go on. And this case went all the way up to the US Supreme Court, which is a pretty big deal. And the US Supreme Court said that the California Supreme Court was right in that it can interpret its own California Constitution in this way. So next slide. Just briefly, I wanted to mention, earlier we talked about the interaction between statutory law and case law. And I noticed in the chat, somebody asked about, well, where do you find case law? Well, the bulk of case law is never seen by you because there's trials going on every day and that never gets published. But if a case gets appealed from the trial court up to the appellate level, then the appellate court makes a decision, and the appellate court can also decide whether or not to have that case published. And so you saw Anne referring to unpublished cases and published cases. The published cases become controlling law. So it's never enough just to look at Davis Sterling. You've got to look at beyond Davis Sterling. I'm sure you've learned that this morning. So the next slide is about the codification of this public square concept and how far it has taken it since the 1980s. In Civil Code Section 4515 of Davis Sterling, this statute is very broad in its protection of speech and assembly in a CID common area, and says that associations cannot prohibit the use of common area for certain types of speech and gathering, including political matters, subjects of public interest, recalls, referendums. And this is the one that I find particularly overreaching, is other issues of concern to members and residents. So that's a very broad category. And what the statute says is that your clubhouse has now become a public square. You can't keep people out of there by charging a deposit or a cleaning fee or requiring that they only use it for certain things. And this applies very broadly, not only to members, but also to residents and even to their invitees and guests. So you could conceivably have a renter who invites 100 other people who are not even living in your association, and you still have to open it up for, if it's for these purposes of free speech. The law also contains a section that says you cannot prohibit a member or a resident from canvassing and from flyer distribution. So just like in the Pruneyard case, if it's on any issue of member concern. So if you have a member who wants to use the clubhouse and says that this is of concern to members and residents, you have to allow that. I mean, this statute has not been interpreted by case law yet, but I would say that that's probably coming. That public square treatment, it was really taken to a new level here. And you can see what happens after, 30, 40 years from when this kind of constitutional control over public property and moved into private property, and what that has now come to. So on the next slide, getting back to the case law that led up to this point, in California, this is long prior to Civil Code Section 4515 in 1982. So this would have been only 2 years after the big Pruneyard case, came the Laguna Publishing versus Golden Rain case. This one is basically a right to free press type of case, because it was about a little newspaper, a free newspaper. This is a large gated community with a security guard and 24/7, did not allow outsiders in, didn't have any kind of businesses located inside. Definitely different from the Pruneyard Shopping Center in that it's not open to the public at all. But nevertheless, the court went a step further here and said that, okay, this is a very large community. I think this one was maybe 1,600 homes. It's in Southern California. And this little newspaper, whatever it publishes, it shouldn't be the only avenue that people have to get their information of this kind. And so the Laguna Publishing, which wanted to come in and distribute, had had this competing newspaper. I think they both had ads in them, and really wanted to get their news out to this particular association. And the court said that that could not be prohibited by the association. So a very interesting outcome in a gated community. Fast forward to 2001, the Attorney General opinion in Golden Gateway case applied this basically the same constitutional protection in a non-gated community, which makes sense because if you're going to find that a gated community is a public square, then a non-gated community, it would make even more logical to call that a public square. Next slide. So well after Pruneyard and after the Laguna Publishing case, came another landmark case in this arena of what's a public forum, and that is the Damon versus Ocean Hills case. This time, this case came about in the context of an anti-SLAPP case. And so just briefly, anti-SLAPP cases, it's a little complicated, but a SLAPP case is, SLAPP is an acronym for a strategic lawsuit against public participation. So in essence, if the lawsuit is being brought to shut somebody up or to stop their free speech, then it might be a SLAPP lawsuit. And the anti-SLAPP motion is a method for dismissing this type of lawsuit very early on before you have to spend a lot of money on it. And so it's a very effective tool to kind of cut the whole thing short in the very beginning. It has to be brought at the very beginning of the case, and it also stops discovery. So it doesn't let the case go on and on. If you're able to win one of these anti-SLAPP motions, pretty big deal. But the first part of winning an anti-SLAPP is you have to establish that this is arising from a protected activity, a constitutionally protected activity. And then once you do that, then you get to go on to the next part, and the burden shifts to the plaintiff to show that their case has a probability of prevailing. So a little complicated, but basically it gives you a great tool to get rid of cases that are really just being brought, not for the merits of the case, but to stop the person that it is being directed at from exercising their constitutional rights. So Damon versus Ocean Hills was about a manager of an association. He wasn't on the board, of course. He wasn't a homeowner. He was the manager, and he was an employee of the association. And this was another really large association. I think it was a retirement community. Had a golf course, had recreational facilities, and there was a journalism club there. So that this was separate and apart from the association's own newsletter. This journalism club formed, and they tried basically in many cases to sort of counteract whatever the opinions were that were coming out of the other newsletter. And they were, in this case, very against this manager. They didn't want him to continue to be employed. They wanted the association to switch to a professional management company. And they published these letters to the editor that various owners wrote, saying that they thought this manager was incompetent, that he didn't deserve to have this job, citing specifics of things that they thought that he did wrong. Well, first of all, the court found that this was indeed a public forum, just as the other cases that we've talked about leading up to it. And again, it was about whether people have the right to this information, and these people had the right to publish their little newspaper and to put opinions in it, which were, contrary to what the manager wanted to have expressed. So the first prong of the anti-SLAPP motion being reached, the case went on to the question of whether it had a probability of prevailing. So Mr. Damon was suing these people for defamation for what they had said about him. And the burden then shifted to him to show that they had said these awful things, that they were damaging to his reputation, his business, etc. But the other very groundbreaking thing about Damon was that the court decided that in this context, the manager is actually a limited public figure. And when you're talking about defamation with a limited public figure, or a public figure in general, or a celebrity or something like that, you can actually tell lies about this person and have that be part of your protected speech. And you won't be found liable for defamation unless you are speaking with what we call malice. So in this case, the court said that that Damon would have to prove malice on the part of these people. And malice means that you do something with the intent to harm someone else. And the court did not see malice in this instance. And so the case was thrown out. Also interesting in the Damon case was that it quoted Narstedt, the case that we talked about earlier this morning, that is often quoted in other cases. And Narstedt, the Supreme Court said that homeowners associations are like their own little democratic society. And so here and in that case, it made sense that they have quite an impact on people, and therefore people who are acting within these realms have their own constitutional rights. Moving on to the next case, we have the Ruiz case, Ruiz versus Harborview in 2005. This one is again in the context of an anti-SLAPP, but it wasn't dealing with a newspaper or a newsletter this time. This time the speech that we're dealing with was an attorney wrote a nasty letter to some owners, interestingly enough. So the association's hired attorney wrote a letter to a couple who had been trying to get their home approved by the Architectural Control Committee, and the request had been turned down. So they didn't give up easily, and they kept coming to board meetings, and they kept sending things to the board because they wanted them to change their mind on allowing this house. Well, the HOA attorney wrote these two letters, which said things like that these people were despicable and reprehensible. And he said that because Mr. Ruiz was an attorney, he should have disclosed the fact that he was an attorney to the board, because somehow that would have made a difference. And because he didn't disclose that he was an attorney, he told him that he was violating ethical rules and a disgrace to the practice and so forth. So the court found that this was indeed part of a public forum, and therefore that the Ruizes have protections, constitutional protections. And the court also found that this was defamatory. So the language in the letter was defamatory, and in determining whether the plaintiff would prevail on the case or had a probability of prevailing, the one thing that was missing to the court was was it published? And so in a defamation case, if you're going to say nasty things, you say them directly to the person, that's not defamation. If this letter only went to the owners who the attorney was accusing of things and defaming, if that's as far as it went, then it would not be actionable defamation. So the court sent it back to the trial court to do some discovery on just that issue. Now note in that case that the Ruizes, who were being badmouthed here, were not public figures, because they're just owners. They didn't put themselves in a position of serving on the board or being the manager. And so the Ruizes did not have to prove malice for their case. Okay, on the next slide, we have a couple more published cases that these are also defamation cases that failed for various reasons. In Haley versus Casa del Rey, which was covered for another reason today, there was also a slander cause of action, and apparently the owner had been accusing another owner of incest. Obviously a nasty thing to say, but it was a non-suit because there was no publication of this. So publication means you have to have sent the letter out to more than just that person who you're accusing, or you had to show it to other people, or maybe you said something out loud where other people could hear it. That would be publication. Wasn't the case here, and so that was a non-suit on the slander case. 2011 case, Cabrera versus Alum. This is another defamation case, and the defamation was going back and forth about candidates who were running for the board. And an owner accused one of the incumbent candidates of fraud and of stealing money from the HOA in the past. The court found in this instance that this board member, the incumbent candidate, was a public figure. And so this higher standard of proof applied where he needed to prove malice. So even if they were saying that you stole money from the HOA and this person never did steal money from the HOA, they would have to prove malice, and thus the case was dismissed. And the next slide happens to be my favorite case on free speech in associations, because this was my case. We took this client on in 2010, and it ended up being a published case. So I should know the facts of this one. Countryside Villas is an association in Morgan Hill with a fairly large number of townhouses. And Susan Ivy was an owner in that development. And there, at some point in time, the board decided to change its interpretation of the CC&Rs. They didn't amend the CC&Rs, but this was the issue of whether the association should pay for balcony replacement or whether the members should pay for their own balcony replacement. And these were not condos, these were townhouses. So about only half of the homes in the association had balconies. So as you might imagine, this made the other owners who did not have balconies a little angry that the board was going to start using association money to pay for balcony replacement. And it happened to coincide with the directors all needing new balconies. And so Susan Ivy organized this group of owners to challenge the board on this. And she did so by having this large group show up at board meetings. And I think she had them do a letter writing campaign. And she definitely got the board's attention, and they were quite irritated by her. They hired an attorney who then went on to write letters to Ms. Ivy telling her that she needed to stop, and she needed to, go along with what the board had already decided, and that if she didn't stop, that they would sue her. So eventually they did sue her. They brought an action that is called a declaratory relief action. And one of the interesting things about this case is it wasn't for defamation, or it wasn't really directing the lawsuit against some speech. If you looked at the face of the complaint, it wasn't about the speech of Susan Ivy, but we argued that it was inherently about the speech of Susan Ivy, because she had been basically told to shut up about this. And as a result of not doing so, they hit her with this lawsuit. And you don't need to name somebody who lives in the association and doesn't even have a balcony when you're trying to get the court to interpret the governing documents on this balcony issue. So we argued that the only reason that Susan Ivy was named was to shut her up. Court agreed with us, and the anti-SLAPP motion was granted. case was dismissed. So the court also didn't think that the association's interpretation of the CCNRs would prevail, and didn't think that it had merit because these were townhouses after all, not condominiums. So one of the reasons that was different from the preceding cases, and the reason the court decided to publish it, was because it was this deck relief action, and it wasn't about, you know, a newspaper, it wasn't about slander or libel, but it lets you know that you have to let the people speak to some degree, that they do have free speech rights within this mini government of the association. Okay, the next case in 2016, this is one of those unpublished cases that we can't cite. It isn't actually law, but I thought it was very interesting, mainly because the board was split on this decision, and the losing directors in the decision decided to sue the directors who had won the vote. And the court found that the actual director's vote is protected activity, and that you can't prevail by attacking, you know, the director's vote. They have a right to vote how they want to vote, and they, once again, in this realm of protected speech, that is included. So that's the Lee versus Silvera case. So next slide. Now, you might be thinking at this point, so what is it that you can restrict with regard to free speech? I mean, is it anything goes, that as long as you're within the context of an association, that anybody can say anything? And that is definitely not the case. So as you saw in, for instance, in the defamation cases, they may arise with constitutional protections within the association, but it doesn't mean that defamation is protected speech. So in certain contexts, like defamation and slander, those are exceptions to free speech rights. And there are always exceptions when it comes to time, place, and manner. So if somebody, say, wants to use a bullhorn in the middle of the night to express their opinion about the board, you can certainly restrict that, because that's not the proper time, place, and manner. But you got to be careful about using time, place, and manner, so that if you're using it in such a way that it really is stifling the free speech or the content, then it will be considered a constitutional violation. Some other examples of free speech that's not protected is workplace speech that can be controlled by your employer, and you don't have, in general, free speech rights in that context. Violent speech is not protected. Violent speech, like, you know, threatening to harm someone, that's not considered protected speech. Obscenity is very rarely considered protected speech. So it does matter the context, how these things come up, and it does matter where these things are being said. Like, is it in a form of art, or is it, you know, directed to harm someone? Those things do matter. Remember that, I guess what you should take away from this in general is that you do have free speech rights going on within your association. It's likely, as you've seen from all these cases, that a court is going to find that your association constitutes a public forum, like a private, like even if it's private property, like a public town square. So be careful what you say. Be careful what things are directed at homeowners, particularly, because you could be liable for defamation. And if you're serving on the board, I guess one of the messages is you need to have a thick skin, because people can tell lies about you and criticize you and get away with it unless these things are said with malice. So that's the end of my presentation. Thank you very much.
Hello, and welcome back to our general session. I want to thank you for being a member of ECHO, but if you're not a member, please consider joining the association. This year, ECHO has planned more than 60 online events. In addition, we offer a vast array of resources for HOA boards and engaged homeowners. We also include personalized guidance on challenging issues and a series of educational programs. You can join ECHO by going to our website at www.echo-ca.org and clicking on the membership tab. For those of you who are interested in meeting in person, we have started our regional resource panels. The next panel meeting will be the Wine Country panel on June 7th in Roanoke Park, California. The topic will be identifying and maintaining defensible space. This is about fire. We also have planned a North Bay resource panel on July 13th in Nevada, which will focus on water conservation and fire prevention. We are excited to invite any HOA board members or former board members to join the ECHO HOA Board Members Club. This exclusive group meets every second Tuesday of the month from 5:30 p.m. to 7 p.m. and features a unique opportunity to learn from your peers. Please consider joining the club. We currently have 220 members sharing information and knowledge monthly. If interested, please click on the sign up sheet in the packet or email Patty at pkurzet@echo-ca.org. If insurance costs are an issue with you and you'd like to know more about how to manage these, please attend the Ask the Expert About Insurance webinar on Thursday, June 2nd. You can come and learn and discuss insurance rates with some of the leading insurance providers in California. I'll note that our sponsor today, Kevin Boland Insurance, will be there as a keynote speaker. Well, this has been a fun program and very interesting. Thank you to Mark, Lori, Ann, and Sharon for your informative presentations. Once again, thank you to our sponsors who have made this broadcast possible for everyone to view. And of course, thank you, the attendees, for participating in today's webinar. ECHO appreciates your investment in education to build better HOA communities.